public-facing organization, because we all agree, right? Municipalities are public-facing organizations. You all, right? So it's true for everyone in the organization, but particularly at the elected and appointed official level, part of the job is delivering good governance, right? Governing body, that's what the state statute says. You're the governing body. Nobody says my job is to deliver, inadequate governance. It's collectively as trustees, as a board, to deliver good governance, which I think both practically and from a risk management perspective is really just dependent upon committing to some core civics principles that I've listed here. And if you commit to those, then I think the related liability issue takes care of itself. And I'll break that down in a minute. Got a couple of examples here. So, but before I dig into that, let me ask this question. We're almost all brand new. This is so exciting. Since you've been on the board, what have you decided? Do you like process? Do you like process? Do you like process? Right? Yeah. Hey, sometimes in government we get a bad rap. Why does it take so long to make a decision? Hey, I just made a simple request. How come you're not going to get to it for all this period of time, right? Why is government so bureaucratic? All that kind of stuff, right? Just remember, from where you sit as the governing body that makes general policies and makes decisions, process in a certain perspective is intentional. Process is intentional in terms of making sure there's time, as I mentioned earlier, for you all to deliberate and make the right decision, right? It's also a vehicle. Process is also a vehicle to make sure that things are properly vetted before you make that decision. And process is also there to make sure that everyone's treated the same, right? That's why we have all these rules about process in the book there, okay? So, now a couple of these civics principles are: commit yourself to openness and transparency, right? And we'll have few, if any, disputes, claims, fights, in my world, litigation over compliance with the open meetings law, okay? We'll talk more about what that means in a minute. Commit yourself to fundamental fairness, right? If you have a couple of requests to come in front of the town board, if you see the same request the second time, you treat it just the same as the first and just as fairly, right? That you commit to being predictable and even-handed. Like if someone comes to the town board, that's true for everyone in the community, but particularly in the business community, if people come in front of the town board with a request, they want to know that they're being treated even-handedly and they know what the rules are going to be. And I don't know what you got that comes up on your agenda from time to time, but let's use this example. Let's say somebody comes to the town board and says, board, I need your permission. I'm requesting your permission maybe to put something in the right of way for some period of time. My property, I just need can I have your permission to put something in the right of way, store some materials or something in the right of way? And maybe you've got a little policy on that, right? The guides thing, yeah, maybe it's okay as long as you meet these requirements. It's not on a curve where you impact sight lines. It doesn't interfere with our access to utilities, whatever it may be, right? That person may come and say, okay, I understand from staff that the things that I needed to submit were straightforward, and I understand the board's discussion was based on these specific standards, and it was a nice discussion. I knew what was expected of me, and the board said, yes, no problem, easy peasy. You don't want to have another person in the same situation, having a vibe where they think, well, that's odd, because when I made my request, it felt like there were new requirements being put on me that I didn't think applied, that there were some strange things going on during the board discussion of my request. And then lo and behold, the night the board heard my request, that's the first time that the board took some novel and unprecedented interpretation of its own rules and turned me down. Does that sound like a good place to be in terms of risk? No. Yeah, these things may not bubble up into a lawsuit, but the actual lawsuit language there is either equal protection or certiorari. Certiorari is just a fancy word for which I paid way too much law school tuition. Certiorari is simply the vehicle by which someone can go to state district court and claim the decision that you made was arbitrary, that you went off script, that you didn't apply your own rules. And if you lose that kind of case, then it's basically the court tells you got to do a do-over. Right? So the real consequence of any of these kind of transgressions is probably erosion of faith and trust in how you as a board do your work together. So you want to commit to those principles. Always another one, this last bullet may sound like even less of a risk management principle, but I really think it is. And it does translate to liability risk. Commit always to civility. right? Mutuality of respect, right? Mutual respect with each other as trustees, equals at the dais. Mutual respect for staff that you interact with citizens that come in front of you. Respect the idea that, as I mentioned earlier, service on a multi-member governing body is a we job. We each bring our own policy perspectives and viewpoints to the board's deliberation, and please do. That's why you have a 7-member board, is so that each person can contribute their own thoughts on an issue, right? Their own perspective on an issue, but you're working towards the voice of the board. So individual success as a trustee must mean, hey, if I want this board to do what I want it to do, I got to collaborate with at least 3 other members to get that majority, right? And we're all going to win some or lose some. So in this flow of municipal work, there's going to be times where, right, you're going to have different ideas and different perspectives, but we want to have respect for each other in terms of how we have our discussions and debates, right? And we need to recognize that in a multi-member governing body, the we is more important than the me. And I'm going to talk a little bit more in a minute about what that means in terms of personal conduct. Okay? All right. Those are kind of some introductory comments from the broad perspective. Let's pivot now and talk about town structure and liability. So within every organizational structure, no matter how large or small, right, everyone has a job description, right? And that's true here in Aguilar, just as it is in our largest member, the city of Thornton or Westminster, right? Everybody, the elected official, do you have a planning commission or a board of adjustment? Do you have any boards or commissions?
No, we don't, right?
Not right now?
No.
Okay. So elected official, full-time staff member, even volunteers under the law have a job description, right? Like if we recruit some volunteers as a town for a town-sponsored activity, hey town, it's clean up the park day, come and be a volunteer for the town and not clean up the park. They have a job. What's their job? Clean up the park. Not hop in a town truck and drive around, right? Unless they were specifically assigned that. And that actually translates to liability risk. So it's important for efficient use of resources, right? And to be able to kind of fire on all cylinders as an organization, that everyone understand and respect their job description. And it's also very important for liability exposure. Okay, and let me explain the liability exposure piece first, and then we'll talk about some other stuff. So it's only been a month or two, it's a couple months since it's been on the board, but I hope your first question of staff or the town attorney at the time was not, can I get sued in this job? Right? But the answer is, yes, you can, right? But here's the good news, and this is good news for everyone, right? Is we have nice protections under Colorado law for public officials. And we want that to encourage public service within the community, right? After all, the part-time citizen volunteers, essentially, who are dedicating their time to help serve in a leadership role on behalf of their community. And you've probably all got full daytime jobs and other things you're doing during the day, so it's a huge ask, right? And there's a lot of ways to get sued out there, right? So there should be nice liability protections. So let me explain what that protection is first, and we'll talk about some of the limits on it. Under Colorado law, we have this statute called the Colorado Governmental Immunity Act, okay? And it basically says that governments and government officials in Colorado cannot be sued except in circumstances where immunity has been waived. And immunity is primarily only waived in areas that generally relate to operations. Like there's a waiver of immunity for motor vehicle accidents, right? There's a waiver of immunity for negligent operation of a swimming pool, those kinds of operational things, right? So for elected officials, it's a very strong protection because there aren't many waivers that apply directly to the work you do as long as we're sticking to the work of governing body, right? But the way it actually works is it says the town, and by extension the town's insurance company, Cirsa, is going to defend you and pay judgments entered against you as an elected official, right? Town and by extension the insurance is going to defend you and pay judgments entered against you for acts or omissions as a town board member. Sounds good. We're protected, right? Like so many things in life, there's a catch, right? And that catch is those protections apply only so long as we are acting within the scope of our employment, okay? And not acting willfully and wantonly. Now, scope of employment probably sounds odd to all of you, because as I just said, you may be thinking, wait a second, I'm a part-time volunteer citizen legislator, policymaker. I'm not an employee of the town. So what do you mean scope of employment, right? So the takeaway for that is, just to keep it simple, is scope of employment is the phrase that's used in the liability statute. It absolutely applies to everyone in the organization, whether you're an elected official, a volunteer, or a full-time paid staff member. And all it means is this, is that one must understand and respect and stay within the scope of authority that they have and limit their activities to the duties that you have under law. That all makes sense? I'll give you easy examples of that. Within the town of Aguilar, under your ordinances, within whose job description, within whose scope of employment is it to decide whether or not someone gets a business license? Under your ordinances. What do you think?
What did you say?
Business license. Business license. Under your ordinance, it says town clerk. So within whose scope of employment ain't it? Everybody else. Everybody else, right? You have I know you have it in your ordinances, but you have a municipal court. Yep, and police, right? You get, the county then will write tickets in the municipal court for you. Okay, so within whose scope of employment, within whose job description is it to decide whether or not someone gets a ticket into municipal court? Yeah, a law enforcement official, a peace officer, right? So within whose scope of employment ain't it? Right? We all agree that we don't individually and collectively have law enforcement authority in the same manner as a peace officer, right? So we have to respect the fact, right? And I get this all, not all the time, but knock on wood, once in a while we'll get claims at Cirsa where somebody, they get their business license turned down. And they sue. And I, as Cirsa's general counsel, I look at that and go, okay, well, this is okay. I look at the order, it's the clerk in her official capacity who's responsible for approval or denial of a business license. So the proper defendants to that claim ought to be the town as an entity and the clerk as the person responsible for issuing the license. But once in a while, we get these lawsuits where people not only name, the licensing official in the town, but they start naming individual elected or appointed officials. And we'll have our defense attorneys call them up and we'll say, well, why are you naming these other individuals? Haven't you read our org chart and our ordinances? Don't you know that it's the clerk's responsibility? So if you have a beef with the decision was made, the only people that are proper defendants are the clerk and the town. And the plaintiff's attorney said, well, yeah, I get that. I read your org chart, but here's my allegation. My allegation was it wasn't the clerk who was pulling the strings, right? That there were other people behind the scenes, right, directing her to turn down my business license. That's my allegation, which is an allegation that somebody was acting, outside the scope of their employment. And in a really bad situation, right, you can see how that leaves you exposed because the obligation to protect you is only for things that you do within the scope of your duties as a trustee, okay? So,
as long as it's the whole board that says no.
yeah, but even the whole, no, in this case, you by your own ordinances, I know it wasn't this board, but your previous board adopted an ordinance that said, in order to run a business in the town, you have to get a business license issued by the clerk. Not by the board of trustees, it says by the clerk. If you as a policymakers wanted to change that, you could, change your ordinances and then on a going forward basis, I guess you as a board collectively could become the licensing agency if you wanted to. But every organization picks and chooses what issues they want to keep for themselves and which ones they want to give away. The overwhelming majority of municipalities in Colorado, no matter how big or small, they usually delegate the obligation and the responsibility for the issuance of things like a business license to the clerk or the finance director or somebody else. Why would that be? Because that's paid full-time professional staff who can be there available to do the intake, to do the vetting of the license, to do all the work that's necessary to confirm whether or not the licensing requirements are met. But yes, to use your example, is to cut to the chase, under your current structure, it would not be within the board's scope of employment for you to decide whether or not a business license is issued. And it would be improper for the board to take over that role, right, unless and until it changed its legislation to empower the board to do that. Does that all make sense? Okay. All right. That helpful on that scope of employment piece? Okay. The other thing is you're protected as long as you're not engaging in willful and wanton activity. That sounds like a weird phrase, right? And willful and wanton conduct is simply this. It's conduct that's intentionally undertaken, designed to injure someone's legal rights, and taken with reckless disregard for what their rights are. I got an even simpler way of describing it. I just call it bad stuff, because that's what it is. All right, and we know what it is, and we're going to stay far away from it, right? But it would be things like misusing governmental authority for fraud or malicious acts, right? We don't get many claims like this, but my claims people tell me, here's the most common situation where there's a risk of willful and wanton conduct. It's almost always, when we get these claims, it's almost always an allegation that an individual elected or appointed official or employee acting individually, right, misperceiving that they had some governmental authority that they actually did not have, throws on that purported cloak of governmental authority individually and goes around doing bad things to people for the wrong reasons. And to give you an example, like in that business licensing scenario, it would be, not thinking of the issue correctly and, conscripting maybe the licensing official into the cause and going after somebody just to make sure they don't get a business license because they're a political enemy or a business competitor. Does those sound like defensible licensing criteria? No, right? Or, conscripting the building official who's not looking at the issue the right way to make sure that somebody doesn't get a building permit just because we don't like them, right? Or intentionally defaming someone, knowing that what we're about to say is maliciously false, right? Those kinds of things. Fraud. Throwing on the purported cloak of governmental authority and using our purported governmental authority to engage in criminal acts. That's all bad stuff. We know what it is. We're going to stay far away from it. But I wanted to explain where the boundaries lie. Because the other important piece of this is that your public official, we have good, strong public officials liability coverage that applies and protects you as long as we're staying within the scope of our employment as a trustee, right? And because the insurance follows the same concepts as the statute, the immunity statute, basically says we cover you, we provide coverage for you as an elected official in your capacity as such, and we cover you for claims that are brought against you when somebody has a beef with something that you did as an official, but not for things that you did when you misused your authority or outside the scope of your authority or engaged in willful and wanton conduct. Okay? Any questions about that piece of it? All right, so that's the state law protection, and it's a good, strong protection. The most practical risk management thing to think about there is, somebody already hit on this, the strongest protections for elected officials are to remember that we act as a board. In fact, you read that whole book. The powers of the board can only be exercised by the board as a whole. There's not a single ordinance in there that says the powers of the board may be exercised by one individual trustee. It just doesn't work that way. So that's your best protection, is to understand that we work together as a board. Doesn't mean we have to be 7-0. It doesn't mean we're not going to have vigorous, strong policy debates, right? It doesn't mean we're going to not have disagreements. But it does mean we have to respect that the authority I have, my scope of employment, is to be a part of the board. Okay? All right. So at the federal level, there's also a strong form of protection. It's called qualified immunity. And we read about that in the papers. Right? And you're protected from federal liability, like federal civil rights liability, but only insofar as our conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. So I'm sorry to be a little lawyerly, but here's the most important or interesting part of that phrase to me is would have known. And I'm sympathetic to the idea that you're just a brand new part-time citizen legislators, and you look at that and you go, how do I know? How do I know? Somebody stands up and says, board, if you do that, if you pass that ordinance or if you make that decision, you're going to be violating my constitutional rights. How do you know? Right? That reaches back to my first suggestion, right? Again, no one asked you the job on the ballot was not governmental attorney, right? You want to get that position filled and you want to get some support around this.
Due diligence is what you're saying.
Do the due diligence. Do the due diligence. Yeah, if they're, ask what our authority is, ask what the limits are. Give your attorney, once you get another one on board, give them a little grace when somebody says, you're violating my constitutional rights, and you all go, attorney, could you write us a memo on that, or could we have an executive session to get legal advice on that? Give the attorney some grace when he says what? It depends, right? Because that lawyerly answer, right? Because in federal civil rights liability in particular, it is a kind of it depends answer. But in terms of your risk management as the board, going back to what you said, due diligence, take the time. A lot of times, not always, but a lot of claims that we get, there's an underlying foundation that we see in hindsight that maybe the decision was made in haste or was made on less than good information. But that's a risk that you can control by and large by, again, slowing things down, and in the heat of the moment, you're individually thinking as trustees, well, we've got this suggestion that what we're doing is improper. Let's slow it down a little bit and make sure we understand what our options are, whether we're on solid ground, and then go forward. Right? Okay. All right.
I actually have one question on that.
Yes, ma'am.
Let's say we got a couple little pending things that we made let's say an improper decision, but we turn around and rectify it.
Yeah.
As quick as we can within the next meeting.
Yeah.
Should we be okay if that,
Yeah, facts, and then looking backwards, facts that exist. And we can't control what others might do with respect to that, but if we know that we've got something that we need to fix, then I think it makes sense to fix it. Yeah. And I don't know if my radar should have been going off, but that's a general comment. I'm not speaking to some specific issue that you got going on. We're all trying to do the best we can, right? And as long as we're in good faith, we recognize, that there's something that needs some correction. Now, that's a difference than, we do something and then one of us doesn't like it and says, well, I'm going to undo that. That's a different kind of risk. I'm talking about the board collectively realizing, hey, we as in exercising our power as a board, we made a misstep. Let's correct that and do it correctly going forward. Yeah. Okay. So I'm sorry to sound a little bit like the Grim Reaper on those, but I wanted you to make sure you understand the limitations. On the flip side, I do want to end on a little bit of a silver lining. On the other hand, don't let the fear of liability drive decision making. Okay? If we know as a board that we as a board, collectively acting as a board, are making the right decision through a fair and defensible process, applying appropriate and defensible standards and procedures, then you're going to be just fine. And that's what these protections are intended to protect you against. Okay? Diligence, thank you for that. Can I borrow that in the future? Diligence is a good protection. All right, let's see. All of this sort of begs the question, what's the town structure? What's our job description as board members? So we spent a lot of time on this. I'm just going to touch on it real quickly. You're a statutory town under Colorado law. Do you all know what the difference is there? As a statutory town, in Colorado, we got three types of municipalities. You got a statutory municipality, home rule municipality. We've heard that phrase, right? And then we got one territorial charter municipality in the state. Statutory means you simply have the powers that are given to you by the state legislature, either expressly or by implication of the statutes that have been adopted. That means the state legislature has defined the powers you have. And even if we wish we had some other power that we don't have, if it ain't there, we can't use it. Okay? Home rule is a distinction. It means home rule municipalities just have a little more power to write. They adopt what's called a charter, which is like a local constitution, which is the platform that gives them a little more power and control over matters of local concern. Doesn't give them carte blanche to ignore state statute. It only gives them more power in matters of local control. And you're not a home rule jurisdiction. Quiz question, there's only one territorial charter municipality left in the state, and they're called a territorial charter city only because they became a city before Colorado became a state, okay, back in the 1800s, and they never reorganized. So they still got like old-timey Western names that they use and stuff like that. Anybody want to guess what the name of that town is?
Moffett.
Moffett, not Moffett, no. It's on I-70 as you head up the hill. Yeah, town of Georgetown. Down at Georgetown. Down at Georgetown. Yep. Yep. And the mayor's not called the mayor. The mayor's title is like chief marshal or something like that. And I still have this vision when you get pulled over that they pull you over on a horse. An old timey Western feel to it, you know. But that's the interesting fact about that. So, but you're statutory, okay? And by statute, what it says is the job of the town board is you are the legislative and governing body, okay? Think of that in terms of analogous to a private corporation. You're the board of directors, top of the organizational chart, primary responsibility for setting policy and for governing the organization, doing things like resourcing the organization and empowering the organization collectively as a board. I know that in the past, and maybe you still have this now, you've had kind of a board administrator or board/clerk administrator form of government, right, where you have delegated certain functions to your administrator, okay? In the broad scheme, if you have the resources, that's a wonderful place to be, because what it does for you as the board of directors, right, it enables you to have a single point of contact and accountability for the administrative side of the organization, right? Because you don't have that time to be full-time, right? And there's a lot of things that need to get done in an organization that it's very time-consuming and inefficient to call a 7-member body together to get every little bit of day-to-day work done. And if you probably think in your own mind of examples of things that need to get done, it's like, do we have to have a board meeting to get that done? That's why you have this distinction between the role you play in making policy and dealing with the governing body level issues, and you have staff to get the day-to-day work done. We all agree on that? Right? To the extent you can, I strongly recommend, suggest that you adopt that board administrator form of government and resource it, right? And find the right balance there between the role of the administration and the role of the governing body. Okay? Another way to look at it graphically is you have to decide, within your sphere as a board, how do we want to spend our energy? I would commend to you to look at the idea of the board ought to be spending its time and energy on ownership and governance issues. Who owns our corporation? The citizens, right? Yeah, so the board is at the top of the org chart, uniquely qualified, right? Think about it. We as a board, you provide a place, this room, a forum for people to come and talk about the needs and wants of the community, and then you decide as the governing body how to put governmental resources on those needs and wants. Okay? That's kind of the high-level ownership discussion. What should the town's policy be, right? And you make decisions like what should the general ordinances be. The town board of trustees ought to have the longest time horizon of the organization. You ought to be thinking about where do we want this town to be in 3-5 years? What should our annual budget be, right? Those kinds of things. So you want to have a long time horizon. You want to keep broad interest in mind. Your primary responsibility is things like general ordinances, the annual budget, right? That should be one of your most important documents. Getting together the budget. Decisions about corporate assets. Should we buy or sell property? Should we make this or that expenditure at the board level? Do you have purchasing policies of any kind? Are there like certain, you don't know yet? We're all just getting our feet wet. All right, well, take time. Staff was going to resource you with like orientation materials to help you understand which jobs are within the board's responsibility and which ones are in the staff's responsibility. And part of that is explaining what the ordinances say. Okay? And if you want to change something, you got to get together as a board and say this is how we're going to reallocate responsibility. Okay? But those are main things that most municipalities have. The governing body is mostly focused on general ordinances, the budget, decisions regarding corporate assets, deciding other corporate matters reserved to the board, appointing and overseeing the board's direct reports. How many total town employees do you have?
3.
3? Yeah.
Or like there's 4, but
Four.
it's actually 3 that are active, unactive.
Yeah. Okay. But the board is not the supervisor of all the employees, right? The day-to-day supervisor? Yeah. That's one place to get oriented to. I should have mentioned this at the beginning. As part of your orientation materials, you all got ordinance number 284 or should get a copy. And that explains the structure that the board's adopted governing the board, okay? And it talks about the relationship of the board to staff and so on. So take a look at that, okay? And if there are things that the board wants to change, then it's the board's responsibility at the board level to get together and talk about those issues.